Excellent. Thank you, Susan. I'm privileged to be addressing you today from South Africa, where I practice as a media lawyer. I'd like to express my appreciation also to the Foreign Policy Center and Justice for Journalists for organizing this timely, important, and already highly informative conference. I also address you today as a panel member of the Neuberger High-Level Panel of Legal Experts on Media Freedom, and I'm grateful to my wonderful colleague, Baroness Helena Kennedy, for her discussion yesterday of the panel's work and for her inspiring address. We will certainly be referencing this conference's work in our work. I'm sure that everyone will agree with me that yesterday's panels were riveting, and I'm delighted that this network of lawyers, activists, and journalists has been convened to debate these burning issues. Because SLAPPs are indeed one of the burning issues of our times. I'd like to take you through a few case studies from my country, South Africa, which to my mind illustrate a parallel mechanism for dealing with SLAPPs, particularly in countries that do not yet have the legislative interventions that are needed. And I especially want to encourage those functioning within common law traditions and systems to explore options within their civil procedural law and their substantive law to address the scourge that SLAPPs have become, even as they agitate for legislative intervention. And that's why I've titled my address, Using the Common Law to Slap Back. If I may ask for the next slide, please. And the following one, please. Yes, thank you. I start with a story about a president trying to silence his critics, perhaps the quintessential slap. Between 2006 and 2010, a South African politician named Jacob Zuma, who became president in 2009, sued the media and other critics for defamation in 15 cases. He sued 8 newspapers, a radio station, 2 cartoonists, a columnist, op-ed writers, journalists, and an artist and an art gallery. Some of the publications that he complained about are on the slide that you see before you, together with one of the 15 writs to give you a flavor for the kinds of cases that were involved. At one stage, the total amount of claims in these cases exceeded 65 million rand, which is about 3 million pounds at today's exchange rate. Considering that the most defamation plaintiffs get in South African cases, generally speaking, even where very serious allegations are made to a wide audience, is about 200,000 rand or 10,000 pounds, our thin-skinned president was valuing his reputation very highly indeed. And what it meant for the defendants in these cases is that they would face years of litigation and massive legal costs to defend themselves. The claims were generally not about factual statements, but critical comments and opinions, satire that were expressed, such as the column that you have on the slide, which criticized Zuma's culture defense in his rape trial. He was ultimately acquitted of rape. So these were clearly lawsuits intended by Zuma to intimidate the media. He left the claims hanging over the heads of his targets for years and had no real intention to litigate, which would have required him to give evidence in the witness box and to be very severely cross-examined on his conduct. So Zuma's strategy, in my opinion, was to silence his critics and chill speech as he ramped up his political campaign to unseat then President Thabo Mbeki and ultimately became the president, as you know, of the country. But he never cared about actually getting his day in court because SLAPPs, which these cases are prime examples of, are all about bullying and intimidating, inflicting litigation, monetary, and emotional pain, and signaling to others that they dare not follow suit. This SLAPP strategy was going well until the brave cartoonist Zapiro, backed by the newspaper publication who published his cartoon and who funded his legal fees, called the president's bluff and dragged him into court in his own defamation case, because by then he was the country's president. I was privileged to represent Zapiro in the case, and we chose a case that would ensure, in our mind, that Zuma's SLAPP strategy would backfire, to use the word of Charlie Holt yesterday, who incidentally is a great colleague of mine on the expert group advising the EU Commission on their anti-SLAPP policy. And of course, the anti-SLAPP strategy that we adopted in that Zapiro case was widely publicized, which is an essential element when one fights SLAPPs, in my view. If we can move to the next slide, you'll see the cartoon that we chose to call the president's bluff on. The case itself, and it is a graphic depiction, this was one of the 15, and this was a cartoon named The Rape of Justice. It was probably the most infamous of the 15 claims brought by the former president, though his suit against the artist for the Lennon parody that you saw up on the screen a bit earlier came a close second. On a very South African note, I should pause to explain the shower head, which Zapiro affixed to Zuma's head in this cartoon, and indeed in all of his cartoons, his later cartoons depicting Jacob Zuma. It was done after Zuma testified, as many of you may remember, in his rape trial, that he had consensual sex with the complainant. And although he knew she was HIV positive, he took a shower after intercourse to ensure he would not contract HIV. After that startling admission in his rape trial, Zapiro invariably depicted Zuma with this showerhead to show what a morally and intellectually bankrupt president the cartoonist believed he was. So the Rape of Justice cartoon, created in 2008, has the following context. This was the time when Zuma and his allies waged a political campaign to ensure that the corruption charges against Zuma were dropped. And in parallel, in the corruption case, his legal team expressly adopted the Stalingrad strategy, saying in court that they intended to fight the charges against Zuma like the Battle of Stalingrad, burning house to house. And that's a direct quote. So the political and Stalingrad legal strategy succeeded. It was only this year, 2021, that Zuma appeared in court on these charges once the court had ordered that they be reinstated after they were dropped by the prosecuting authorities some years ago. So Zapiro, the cartoonist's criticism in 2008 was classic fair comment that the president was, then the president in waiting, was abusing the justice system based on the statements made by him and his allies and his legal team. And his allies, for instance, had said things like there would be blood on the streets of South Africa if Zuma was prosecuted for corruption, and that the judges of our highest court, the Constitutional Court, were counter-revolutionaries. So having sued over that cartoon, one would have expected a wronged litigant who wants to clear his name to act proactively to get to court, but not President Zuma. Instead, in a manner that was not unlike his Stalingrad legal strategy in his corruption case, Zuma took every technical point he could in the lead up to the defamation trial that we dragged him kicking and screaming to. For instance, he had to be compelled by 2 court orders to discover relevant documents. Another stratagem of his was to refuse to admit that the public statements by his allies had been made. And so when we obtained video evidence of these statements, he again objected, saying they would argue that the case was not ready because the evidence had been submitted late. The climax of the procedural blockade was that on the very day that the case was called in court, Zuma unsuccessfully argued that the case had been wrongly enrolled because 2 different case numbers with 1 digit differing had inadvertently been used. All of this, as I've said, received massive publicity, and civil society was firmly behind the cartoonist Zapiro. And indeed, as I say, the SLAPP strategy backfired, with Zapiro mocking Zuma in other cartoons. If you go to the next slide, you'll see some of them. And indeed, going so far as to calling Zapiro his publicist, calling Zuma Zapiro's publicist. Of course, as we reflect on that cartoon, Zapiro had the luxury of being able to do this as a successful, well-established, internationally renowned and award-winning cartoonist by then, who was backed by his publisher, like Steve Kinane told us about yesterday in his testimonial about his Fair Game book and the Church of Scientology. But others are not so lucky. Freelancers, social activists, community journalists, students, non-profit organizations, bloggers, etc. And even big publishers have much tighter legal budgets now, and litigation is, of course, never a good investment in any event. And as Steve reminded us yesterday, the emotional and physical investment in litigation, even if your fees are paid and you have lawyers acting pro bono, extracts more than its pound of flesh. I was especially struck by his point yesterday about the opportunity costs of forfeiting other stories as you immerse yourself in defending your case. Because, after all, litigation, particularly against an investigative journalist, is a declaration of war, and it's a war the investigative journalist cannot afford to lose. So by design, the SLAPP, such as Zuma's SLAPPs, intimidates those who are slapped from carrying on with future work on the same theme, as Paul Radu emphasized last night. And I recall an artist in the case I was involved in facing not just a defamation lawsuit, but allied physical intimidation, saying to me, although only partly in jest, that he should stop doing political art and rather do artworks of the flora and fauna of the Cape. Back to the Zuma trial. Our anti-SLAPP strategy succeeded. On the eve of the trial in 2012, where there was nowhere left to hide, and Zuma knew he would lose in an embarrassing and very public way, he withdrew his defamation case, as you'll see from the next slide, which is the anti-SLAPP victory as depicted by Zapiro in this classic David and Goliath cartoon. What's more, within the next few weeks, Zuma withdrew all his other cases. Of course, he tried to spin it to look like he had done nothing wrong, ironically saying he was doing so in the interest of freedom of speech, but no one was fooled. All of which brings me to how we should deal with SLAPPs in the law, because if anti-SLAPP laws were around in South Africa at the time of Zuma's defamation suing spree, the defendants, of course, would immediately have turned to the courts for swift redress. South Africa's law has moved on since the Zuma defamation cases. Most importantly, on the political scene, Zuma is no longer president. And I might add, in a contemporary footnote to the Rape of Justice cartoon, a decade after his capitulation in that defamation case, Zuma was jailed, albeit very briefly, for deliberately defying an order of the Constitutional Court, which required him to spill the beans on the capture of state by his friends, the Gupta family, during his presidency. And in fact, as the next slide will show, Zuma returned to the Lady Justice theme in depicting this momentous occasion in South Africa's democracy just a few months ago. If ever, a metaphor for the wheels of justice turning slowly. Now, despite the fact that South Africa, in common with other African countries, has no extensive jurisprudence or legislation on SLAPPs, there have been, as I say, developments. And in fact, this year, our high courts have handed down two important anti-SLAPP cases without any need for legislative intervention. So a critical point I'd like to make today is those who operate in countries who are working in the common law tradition or who have equivalent civil procedure tools to do so should not wait for legislation to regulate SLAPPs. Of course, it's the case that anti-SLAPP legislation should be passed in all democracies that take freedom of expression seriously. But until they do, litigants should use the common law and civil procedural mechanisms that may be available to them to develop anti-SLAPP legal responses. And of course, law, as we all know, is really only one of the many ingredients needed to successfully oppose SLAPP strategies by the powerful. So these two cases in South Africa, which I'll briefly deal with, have done exactly this. They've acknowledged the phenomenon of SLAPPs under common law, so that activists are now able to use the common law to slap back. The first way, and if I can go to our next slide, the first way that our courts have recognized this is in a less ambitious form, to allow punitive costs against the plaintiff after a failed defamation case for bringing it abusively. And the case in question also illustrates how SLAPPs are used to stifle digital public participation, and how its targets need not be activists and journalists, but may well be ordinary citizens, as long as the chilling effect is achieved. Meet on this slide the tweeter who was the subject of a SLAPP by the former head of South Africa's embattled power utility company, who is a controversial figure who has faced criticism in the context of the state capture by the Gupta family of the public utility. He denies any wrongdoing. The tweeter, as you can see from the slide, is a 72-year-old headmistress or principal of a preschool, and she had 141 followers on Twitter. The plaintiff sued for a declaration from the court that what she had said about him was false, an order that she remove the tweets, that she apologized to him, and that she pays him R500,000, which would likely be more than the average preschool principal's annual salary. What she had done, the principal, is tweeted, "You stole so much that I'm so sick of your innocent ramblings," in a reply to a tweet that he had made, that he had published, the plaintiff, professing his innocence. After he sued, she shut down her Twitter account, never to be seen again. The plaintiff spurned her offer to apologize, but took no steps to take the defamation case forward, much like Mr. Zuma's strategy. If we can go to the next slide, the case eventually got to court, thank you, when the principal secured legal representatives who would take her case on a basis that was favorable, and particularly on a contingency fee basis, which means they don't get paid unless costs are awarded against the plaintiff. Ms. Tanton, the principal, argued that because the lawsuit was a SLAPP and had no merit, she should be awarded punitive costs. And she had excellent evidence of the motive of the plaintiff in suing her. He had given a radio interview 2 days after suing, and I quote from the interview, saying, "She needs a big clap so that others can learn that the time for impunity is gone." I must again, for the non-South Africans in the audience, translate that clap is Afrikaans for a slap. And a better admission of a SLAPP motive from a plaintiff, I venture to suggest, would be very hard to find. A month or so ago, the court held that the plaintiff's case was an abuse of the court process. He was not entitled to any relief, and he had to pay punitive costs, meaning a higher level of costs, of course, than would ordinarily apply. Apparently, he is appealing. Now, while this result is undoubtedly correct, there are obvious disadvantages to only punishing slappers by awarding costs, even punitive costs, at the end of a trial. Most significantly, of course, the defendant has to go through the emotional and financially ruinous process of what will often be a lengthy, all-consuming trial before they are awarded costs. The better way to use anti-SLAPP mechanisms under the common law is to develop a substantive defense in its own right. And this is exactly what happened in the second case decided in February this year, the Western Cape High Court's decision, if we go to the next slide, in the mineral sands case, which is a classic case of a battle between a multinational mining corporation taking on environmental activists. Now, for almost a decade in South Africa, there's been public concern about the activities of the Australian mining corporation, Mineral Commodities, and its various South African companies, including mineral sands. The attempts by the corporations to mine a 22-kilometer stretch of pristine beachland in the Eastern Cape and on the west coast of South Africa has resulted in debates, community activism, and legal challenges. Critics see the potential mining as resulting in the permanent destruction of fauna and flora for the short-term and private benefits of titanium mining. And of course, what will my political artist have left to paint if the flora and fauna of the Cape are destroyed? Among the voices who participated in the public discourse were 3 environmental attorneys and 3 activists. If you go to the next slide, you'll see that from a little sample, they criticized the corporates in books, radio interviews, and in the case of the 2 attorneys, presented a lecture at the summer school of the University of Cape Town. If you can go to the next slide. The response of the corporates was to bring defamation actions against the 6, claiming that its corporate reputation and the reputation of some of its directors had been damaged to the tune of over 14 million rand, which is almost 700,000 pounds. The social activist, one of the defendants, was sued for 28 different publications, albeit under the umbrella of one writ. My firm took the case on a pro bono basis, and we pleaded a substantive SLAPP defense, uncharted territory in our law. We argued that the mining company's conduct in bringing these cases amounted to a SLAPP, which should be recognized as a substantive defense under common law, even in the absence of legislation. And we did so because we said the courts have powers and inherent powers to ensure that their processes can't be abused. The allegation that we made was that the company's cases were brought for the ulterior purpose of chilling criticism. The companies responded, amongst other arguments, that a SLAPP defense couldn't be used because it would have to be created in legislation and couldn't be developed in the common law. Now, I should emphasize that the court did not find on the facts that a slap was made out, because this was an argument in principle at a preliminary stage of the case. But the judge beautifully named Goliath, a good Goliath, in a sweet twist on the biblical story. Goliath upheld the principle that a defense of slap is available as a species of abuse of process in the common law. And if we go to the next slide, and I won't read everything, you will see that, for instance, taking the bottom half of the slide, Judge Goliath said, litigation of this nature poses a serious threat to the defendant's participation in matters of public importance. Public dialogue and debate on matters of public interest must be protected and encouraged. Any legal action aimed at stifling public discourse and impairing public debates should be encouraged. And the next slide, to the point of my address to you today, she said, in the absence of anti-SLAPP legislation, picking it up from the second sentence, courts have limitations to cure the symptoms of SLAPP. This lack of a legal framework could be exploited by corporates and in the process render civil society vulnerable when they embark on pursuing legal challenges and raising legal defenses. This contributes to the success of the SLAPP, since such legal challenges and defenses have a draining effect on public purse and participation. However, the interest of justice should not be compromised due to a lacuna or the lack of a legislative framework. So the court's recognition that there is a way our law can guard against SLAPPs is of profound importance to South Africa and to the African continent, where there is no developed SLAPP jurisprudence. And it means that if upheld on appeal, because it is being appealed, the SLAPP defense can probably be heard as a separate part of the case before the remainder of the case is heard, which is a far better proposition than having to litigate a case to completion before arguing that it is a SLAPP or that punitive costs must be awarded. And it's a way, of course, of achieving something akin to preliminary hearings on SLAPPs, which we heard about, and of course, which is very popular in the United States, in some states in the United States, and which many of you have rightly said yesterday should be a key feature of anti-SLAPP legislation. Next slide, please. And I am coming to a close. I see I've overstayed my welcome slightly, for which I do apologize. As I was saying, the mineral sands case is being appealed to our highest court, the Constitutional Court. It'll hear argument on the 17th of February next year. And there's another aspect of that case that I should mention, because what we have brought to the Constitutional Court on behalf of the slappees, not the slappers, is the important question of whether corporations have the right at all to sue for defamation, to sue for damages for defamation. And it's an argument which, though not SLAPP specific, if successful, will also enhance the right to criticize without fear of ruinous damages claims being brought by corporations. I hope I'm able to report in due course that the Constitutional Court has upheld the common law defense of SLAPP and the fact that corporations should not have the right to sue for defamation. But more about that in the coming year. 3 reflections in closing, if you will permit me. In her excellent book, In Sullivan's Shadow, the US academic Amy Edmondson studies around 40 cases in the years before and after New York Times versus Sullivan, where police officers, public officials, and prominent public figures brought defamation claims, as she puts it, used SLAPP suits to silence speech about civil rights and punish the speakers and those journalists who wrote about them. As Edmondson says, SLAPP plaintiffs rarely win in the US nowadays, but she reminds us that the urge to silence dissent continues, and she highlights stats that show government officials in the US asked Google to remove over 15,500 items from various online platforms from 2011 to 2015, citing defamation. Although these were not lawsuits and Google did not simply accede to each request, the L in SLAPP is sometimes not a lawsuit but a letter with similar deleterious effects on public participation. Sarah Clark, Susan Cocktree, and others made the same point yesterday. Secondly, countering the SLAPP scourge is too important an exercise to wait for the legislative process to unfold. In parallel to this process, at least in countries where this is possible with some creative lawyering, I urge lawyers and activists to seek to develop the common law, to slap back, even as we reinvigorate efforts to deal with SLAPPs and the policy and anti-SLAPP policy at the legislative level. And finally, I would emphasize that SLAPPs should also be seen in the broader context of other areas of law which continue to oppress, persecute, harass, detain, and even in some countries assassinate truth speakers and truth seekers. And adopting best practice to counter these threats lies at the heart of the work of the high-level panel. A good place to start, though the tip of the iceberg, but one that I suggest will immensely assist in countering SLAPPs, would be to decriminalize criminal defamation and insult laws, not least given that, as documented in the excellent research conducted by Lady Nancy Jaramillo, slapped but not silenced, 63% of SLAPPs in that study involved criminal charges. I thank you very much for listening, and I look forward to our further engagements. It takes a village to fight a SLAPP, and I'm very honored to be a resident of this particular anti-SLAPP village. Thank you very much.